When you die, will you be burdening your family? Will you be leaving them with a financial mess? This is a common conversation I have with my retirement planning clients. And in this video, I wanted to share with you some of the estate planning mistakes that could be very costly to your family and could potentially cost you some sleepless nights. But before we get to that, I want you to subscribe to our channel by hitting the link below and to be notified when we post new videos. So this topic came to mind for me at a recent headline where I read that the CEO of Zappos, age 46, passed away with a net worth of $840 million. He had no will, leaving his family with quite a mess. And he's not the only notable. There are many out there. Prince, Jimi Hendrix, Aretha Franklin, Martin Luther King Jr., and going all the way back to Abraham Lincoln. Some of these folks were very wealthy. Some of them may not have been so much so. But regardless of the amount of wealth that you have, a proper estate plan will help you to set in place the structure so you don't leave a financial mess for your family and burden them at a time of obviously emotional distress with an additional duress of having to deal with a completely disorganized financial situation. So what is estate planning? Let me give you my definition. To protect and preserve your assets so that when you pass, they go to the people who you think they should at a time when the money should be going to them, and with language, if you use a trust, that you indicate how the money should be distributed. And if somebody isn't supposed to get money, who isn't supposed to get that money and why? And during your lifetime, in the event that before we pass, something happens and we are infirmed, giving instructions to the proper people in terms of how to take care of our affairs while we're still alive, but have some form of incapacity. So let's have a discussion about some of the W's, if you will. Why you should do it, when you should do it, who should do it, and what is involved with estate planning. Now let's start with the why you should do it. Let's assume, like many of my clients, they're married. One of the big conversations or fears that they have is if one passes, how is the other, the surviving spouse, going to be taken care of? And estate planning is a big piece of that. And we've talked about, the retirement income planning portion of the overall planning and making sure that when the two of you are still here, you have enough income to pursue your life. But, particularly, if I'm married, I want to make sure my spouse is taken care of if I'm no longer here. And the estate planning will identify what types of assets would be available, what type of income you can have, so that you can make sure that he or she is going to be able to pursue their lives unburdened. Let's say you have kids who are still in, teenagers, and you want to make sure that they go to college. Or you have grandkids, again, getting back to the education portion of it, that you hope that will be able to get through college. You may want to make sure within your estate planning, you've taken care of that aspect of your life. Maybe you are in a blended family, a second or third marriage, and that lends to some more difficult, more complex issues. But if you don't leave the proper documentation, you will certainly guarantee your family quite a mess when you're gone. And we talk about when you're gone, it's as much as when you're here, and if something happens to you, you certainly don't want to burden your family if there's a long-term care situation. So having in place the proper documents or insurance to protect and preserve the assets and your lifestyle are also important. There's many different reasons why you should have an estate plan. And for each of you, it will be specific to your own personal situation. But my guess is that there is something out there that will prompt you and should prompt you to update or at least initiate an estate plan that will cover for why, from your perspective, it's important to have one. So let's go to the second W, the who should do it. And I think just about anyone, with or without assets, who has a responsibility to others should have an estate plan. Again, it doesn't doing an estate plan doesn't mean that you have to get to some threshold before you have the reason to have an estate plan. Just because you do or do not have $100,000, $500,000, $500 million should not be the reason to do or not do your estate plan. It's not about how much money you have. It's about what kind of responsibilities or people or situations will be left behind when you go or something happens to you. So let's go to the next question of when you should do it. And it sort of also goes into the who. It's about responsibility. And once you get to that point in time, you should have a basic estate plan in place. And I'll give you an example. My daughter. So my daughter doesn't really have much in the way of assets, but now she has my 6-year-old granddaughter. And I told her 3 or 4 years ago that she needed to put in place estate planning documents so that if anything happened to her, her daughter, my granddaughter, would be taken care of and language would be there so that it wouldn't leave a mystery in terms of what should happen with her daughter, who should be taking care of her, what should happen. So even though she was in her 20s and had no assets, she had responsibilities that would be left behind if something were to happen to her. So the when and the who are sort of interrelated. It all depends on what your circumstances are and who you need to take care of. Now, in just a moment, we're going to take care of and take a look at some of the common mistakes that can be very costly to you. But I wanted to address the last W, which is, what is it? What is involved with estate planning? At a very basic level, and I'm not an attorney, I'm just a certified financial planner, having done retirement planning for 32 years now. But we do guide our clients in terms of how to think about what is necessary when they go and talk to their estate planning attorney. A will, a durable power, a healthcare proxy, and for some, a trust, be it a revocable or irrevocable trust. Now, the healthcare proxy and the durable power are two very important instruments that address a time when you may not be able to communicate what your wishes are or be able to tend to what the daily needs are. And those two documents set up a person who will be able to take care of either your health care needs or your financial needs. A trust may or may not be something that is important in your situation. Sometimes you want to identify who gets what money, when they get it, in what circumstance they get it, how much they will get it, whether or not they won't get any. When it comes to those types of issues or concerns, a trust might be something that you might want to talk to your estate planning attorney, and it may be a revocable trust, which means that the day after you set it up, you can rip it up, or an irrevocable trust, which means once you put it in place, it's there forever. And it's important to have that conversation with the estate planning attorney and to make sure that you understand the pluses and minuses, particularly as they are gauged against what your objectives are. And most importantly, one thing that people tend to forget, and a lot of my clients do, when I say to them, when was the last time you updated your estate planning documents? Oftentimes the question was, 20, 25, 30 years ago. But life has changed and your objectives has changed, and you may have had more assets now and more things you need to think about. I would submit to you, and our industry pretty much says that, every 3 to 5 years, have a conversation with your estate planning attorney, review your objectives. If life changes in between here or there, make sure that your documents reflect whatever it is that has happened within your life. But set it in place initially, and then every 3 to 5 years, just take a quick look at it or have a conversation with your attorney. So I'm going to talk about just 4 of the mistakes that could end up providing a real burden to your family or just a big financial mess. Okay? So the first is improper beneficiary designations. So on your IRAs or your 401ks or your annuities, those will be distributed to the person you designate as the beneficiary on those plans. You can have a primary beneficiary, and then you could have a contingent beneficiary if the primary is no longer there. Oftentimes when you set up the annuity or the IRA or the 401k, typically, the spouse is the primary beneficiary, and sometimes there's the ability to put in place a contingent in the event that something happens to both of you. But what I find more often than not, you set it and forget it. And life changes over time. You may have had that 401k for 20, 30 years, and Aunt Molly was the contingent beneficiary on the 401k who passed away 12 years ago. So you need to update that because that could cause a lot of confusion and a lot of cost. The second big mistake is not understanding the impact or the cost of having your estate go through probate. It could take 6, 9, 12 months, maybe even more, depending upon the size or complexity of your estate, if it ends up going to probate. And if it goes to probate, that money is not available to your heirs during that time. And the cost of going through probate could be also a burden to your family. So if you have assets that you would prefer to not go through probate, you may want to talk to your estate planning attorney about a revocable trust, which would help to accomplish that goal. If you have real estate that is in a state that is outside of your primary residential state, then you may want to talk to your estate planning attorney about having that piece of property that is outside of your residence and your residential state not go through probate. That again can be a costly and an event that can burden your family and handcuff them in terms of things they wish to do in a timely manner. The third mistake is not understanding the impact of federal or state estate death taxes. Now, for most people, they're not going to be burdened with, or the estate won't be burdened with, the impact of federal estate death taxes. It's upwards of $5.6 million at this point. For a couple, that makes it about $11.3 million that is sheltered with proper estate planning. Those numbers may come down in this current administration, but regardless, many people will not have to face the federal estate death taxes. But what they may not realize is at the state level, depending upon where you live, there may be a death tax there, and that could be costly. And if you don't understand that impact and haven't planned properly for that, again, you may burden your family with a financial mess. I'll give you one particular circumstance. I had a client whose father owned numbers of pieces of real estate here in the Boston area a number of years ago. He was really pretty much a control freak, wanted to do everything on his own, didn't want to do the necessary estate planning, and when he passed along quite a mess to his children. They not only had to liquidate the properties once they got out of probate, but had to pay taxes on top of that. And what was a very healthy estate while dad was still living became just a portion of that available to be passed along to his kids once the death taxes and regular taxes were paid on it. So it's really important to get a handle on that now and not wait. The fourth mistake and last one that we'll talk about here is poor insurance planning. Now, I have talked to all of my clients about long-term care insurance, and it's important to understand what it can do in terms of while you're here and now, but something's happened, how it can protect and preserve the assets, not just for you, but for your spouse as well. And you need to plan for that in advance. And what I mean by that is, I had a client a number of years ago, and we had talked about long-term care insurance on a number of occasions. And she said that she really didn't want it. Understood. My role is just to educate, and then you as a client, you've got to make an informed decision and go one way or the other. And she chose not to purchase it. But on a particular Friday, I get a phone call from her, and she says, "You know what? I think it's time. I think I'd like that long-term care insurance." And I was like, "Really? Okay. Why? What happened?" And she informed me that the very next Monday she was going into the hospital to have brain surgery. Well, obviously disappointed that she was going in to have the brain surgery and hoping that she was going to come out all right. But it was a little late at that point in time to be thinking about taking out long-term care insurance. Deal with it while you're healthy. It's a lot easier to do that. The other is life insurance. Life insurance can be a great tool when owned properly inside an irrevocable life insurance trust, for example, to pay for some of the estate death taxes either on the federal or the state level. So those are the four common mistakes that we talk about with our clients that could end up costing the estate lots of money, burdening the family members. And there are many more issues and items that we could discuss, but you should be talking about that with your financial advisor or your estate planning attorney. I hope you've enjoyed this session with me. And I really, truly hope that you enjoy the retirement journey while we're here and healthy and we can. Make sure that you take a look at our playlists below and fill out the quiz that we have available that addresses whether or not you're prepared for retirement.